Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to discuss a topic that I've discussed fairly frequently on this channel, but I've never really made a specific video where I just get right to the point of it. This question comes up frequently out here. Why do tourist visas often get denied to Thai nationals? And I would say that that's actually something of a misnomer. I don't think that tourist visas often get denied to Thai nationals. I think that tourist visas often get denied to Thai nationals who have a relationship with an American citizen, or lawful permanent resident for that matter. And basically, what am I talking about here? Well, there are many Americans who come over to Thailand to live, work, or for recreational purposes. They meet someone in Thailand, and they want to bring them over to the United States, and they want to show them around the U.S. Sometimes people can be romantically involved with these individuals. Seems to be more often than not that that's the case, but I have done cases for folks that weren't necessarily romantically involved with anyone. It was more just, a friendly kind of a thing. Pursuant to what's called Section 214B of the Immigration Nationality Act, which I specifically discuss at length on another specific video called 214B of the Immigration Nationality Act, we discussed the analysis that consular officers have to make with respect to strong ties to the home country, namely Thailand, or a third country outside of the United States, and weak ties to the United States. A relationship, romantic or otherwise, with an American citizen can trigger certain mechanisms in a consular officer's analysis of an application for a U.S. visa, which can cause them to basically scratch their heads and say, hey, does this constitute a relatively strong tie to the United States? A strong romantic relationship, I think, clearly does. Things like fiancé and marital relationships clearly constitute a strong tie to the U.S. And in those circumstances, the American citizen needs to show that they, in fact, are tied to Thailand, especially like a marriage situation. A work permit in Thailand, something like this, can go a long way in showing their strong ties to Thailand, which will show that that individual Thai that may be married to an American citizen is going to come back. That being said, pursuant to the doctrine of consular absolutism or non-reviewability, consular officers in the context of 214B analysis have wide discretion with respect to making factual decisions on the ground, and their factual decisions and their interpretation of the law arising therefrom is going to be virtually considered non-reviewable. It is non-reviewable. In fact, it's not subject to an appeal or anything. So basically, yes, it's unfortunate insofar as you do see a fair number of denials, especially for those Thai nationals who have a relationship with an American citizen. But based on 214B and based on the legal and policy tools granted to consular officers who are adjudicating visa applications in Thailand, they're operating well within their bailiwick in denying such applications. And I shouldn't say unfortunately, but I do. For those who don't understand how this legal analysis works, it can be very frustrating because they simply think, well, I applied and we presented documentation and we were just sort of summarily denied. There's a reason for that. There's a framework under which these consular officers have to operate and have to analyze cases. And under that framework and with the tools that they're given, they're going to very often, in fact, it's my experience, kind of more often than not, are probably going to find that those Thai nationals with relationships to American citizens don't meet the test under 214B and therefore need to be denied pursuant to the Immigration Nationality Act.